Hello, everyone. I am Audra Doyle, and I am the owner and attorney of Doyle Law here in Atlanta, Georgia. Today, I'm going to talk with you about a petition that my firm files a lot, which is called the H-1B petition. The H-1B is a working visa. It's a temporary working visa, and it does not lead to permanent residency in the United States. It's usually valid for 6 years. And most of my clients have to go through a selection process, which we call the H-1B cap. So today I'm actually filing one of my cap cases. And as you can see, it says H-1B regular cap, and it's asking for a change of status and extension of stay. The things that are required for this case are, number one, that the job be a specialty occupation, where the company needs someone who has a specific degree to do that job. It cannot be a position where several different types of degrees can be acceptable. The degree needs to be at least a bachelor's degree, although it could be a master's or a PhD. And also, the H-1B approval depends on the job duties, the job title, and the requirements of the company. It does not depend so much on the beneficiary. So, for example, if you have a job as an engineer at an engineering firm, the job title is engineering technician, and they will not be performing the duties of an engineer. And the company says, well, for this engineering technician job, we need an associate's degree. So the foreign national, the applicant, comes in and they say, well, I have more than an associate's degree. I have a Bachelor of Engineering in Civil Engineering. That's great for the foreign national that they have such a wonderful degree. However, the position itself does not qualify for an H-1B because the company has told me they don't need a bachelor's degree. They need less. They just need an associate's degree. So I would have to work with the company, the beneficiary, to see if the job offer can be as an actual engineer, because engineers need to have a 4-year degree to do that job. Other requirements are that the company pay the H-1B worker the prevailing wage and that it promises not to depress the wages of U.S. workers. We have to work with both the Department of Labor and also the USCIS on this case. We have to notify workers in the company that an H-1B position is being filed, and someone will be hired for that. And the company is also required to keep a document called a public access file. So my firm also prepares a public access file, sends it over to the company with instructions on how to maintain that file, because the Immigration Service could send a team to check it out. So the company needs to be prepared, and it's my job to know all of these rules and to properly advise both the company and the foreign national, number one, if they're qualified, and number two, any weak points of the case. Even after doing all of this work, we have a strong case. We file it with immigration. Everything looks good. These days, in the year 2020, we could still get a request for evidence. Immigration has significantly raised the number of requests for evidence that it is sending out for H-1B cases. And my firm has a lot of experience responding back to immigration in a strong manner, and we often get these cases approved. I hope this information has been helpful to you in seeing if you might have an H-1B case. And if you need help with your immigration matters, please contact my firm. Thank you and have a good day.